But first tonight, the Larrakia people have long been acknowledged as the original inhabitants of the Darwin region. But for the past decade, they've been testing their legal recognition in the courts. Last week, they lost the first native title claim over a capital city. A federal court judge ruled that while today's Larrakia have a vibrant and dynamic culture, their traditions weren't continuously practiced because of white intervention. The claimants are vowing to fight on, and they'll meet tomorrow, Saturday, to discuss a planned appeal.
So I think Darwin is very fortunate that we have this presence that goes back countless thousands of years, and we're so lucky that we do have their ongoing wisdom here. So many parts of Australia are denied that.
It wasn't until 2000 that the Larrakia had their first big legal victory, winning the Kenbi land claim over the Cox Peninsula across the harbour from Darwin. The case took more than 20 years to resolve and raised hopes about the prospects of a separate native title claim over 30 square kilometres of undeveloped land in and around the city itself. But last week, those hopes were dashed.
The present laws and customs of the Larrakia people reflect a sincere and intense desire to re-establish those traditional laws and customs adapted to the modern context. That, however, is not a sufficient factual foundation for making a determination of native title rights and interests in this proceeding.
How are you? The Larrakia native title claim began 10 years ago and evidence was first taken in 2002. Justice John Mansfield heard some of the evidence outdoors in special sessions held around Darwin. But ultimately the Larrakia were unable to prove their laws and customs had been continuously practiced and their claim was rejected.
The evidence shows that a combination of circumstances has, in various ways, interrupted or disturbed the presence of Larrakia people in the Darwin area during several decades of the 20th century.
To say that there's been interruptions and in fact lost and relearned is from my family and my point of view, is untrue. In fact, as I said just before, the knowledge that I have was handed down through my mother, my grandmothers, aunties and my family connections.
Well, the Kenbi claim was run under different legislation altogether, the Aboriginal Land Rights Act, which is a contemporary act that deals with what the situation is now, but the Native Title Act requires continuity back towards sovereignty, and that doesn't mean that people have to live exactly as they did before the British Crown asserted sovereignty, but the laws and customs need to remain substantially connected.
So what does the failure of the Larrakia claim teach us about what native title can actually deliver to Indigenous Australians? Has the bar been set impossibly high for Aboriginal people to prove continuous practice of traditional laws and customs? Joining me now live from Canberra is Dr. David Martin. Dr. Martin was an anthropologist in the Wick native title claim and has advised land councils and state governments on native title. David Martin, welcome to the program.
Hi Melinda and hi to your viewers.
Did the federal court's rejection of the Larrakia claim surprise you?
Not really. I can see why Larrakia people themselves would be so bitterly disappointed, but the facts are that over the last several years it's become more and more difficult, in my view as an anthropologist, for Aboriginal people to prove native title, and it would be doubly difficult in a situation such as was facing the Larrakia in Darwin.
Well, let's talk about where the case did seem to fall over, and that was this notion of the continuous observance of traditional laws and customs. Has that idea of continuity always been the substance of native title legislation?
It was certainly a feature of the original High Court decision, the original Mabo decision. It was reinforced in the amendments to the Native Title Act in 1998, and it's been subsequently, I suppose you could say, tightened up even more with the decision of the High Court in the Yorta Yorta matter in Victoria, which really prescribed quite a high test for what is to be understood as traditional laws and customs that Aboriginal people have to show.
How has that test changed? In your experience, how has the definition of native title actually changed in layman's terms?
In layman's terms, it's now necessary for Aboriginal claimants to show that the laws and customs under which they have connections to their country is essentially what it was at the time of sovereignty, although with some adaptation to allow for, you know, modern conditions and for what's happened during history. But in essence, I suppose to put it in a nutshell, what native title does now is merely to entitle Aboriginal people to be native, that is, to be traditional, as required by native title law. And there's a paradox there in a way when the thrust of other government policy in welfare areas and so forth is that Aboriginal people should integrate with especially the mainstream economy, and yet here we have legislation and court rulings which require people to be traditional, and I think this was the paradox that was confronting Larrakia people in Darwin.